this whole theory of opening the door, okay? That is a common phrase, a common term that you and I talk about, hear about, every lawyer hears about. But for the lay person that's sitting out there, when somebody asks a question and the other side stands up, an objection, Your Honor, and then I say, well, no, he opened the door on direct examination, or he opened the door on cross-examination. What am I saying? What does it mean to open the door, and what is the consequence or the potential consequence of that?
So opening the door it's a figurative way of putting it, but it's a really good descriptive way of putting it, and it's in common parlance and evidence terms. People say it all the time, right? So generally what opening the door means is that there's an issue that's not relevant to this particular case, or a piece of evidence that's inadmissible for some other purpose, right? Let's say there's a letter in a case, and that letter could be deemed, or a voicemail or something that could be deemed hearsay. There's no way to authenticate it appropriately. Well, it's not admissible for you to put it into evidence against me as a defendant.
So in that situation, the judge, I've tried to get it in.
Right.
You've objected.
And the judge,
on the grounds that it's hearsay, and the judge sustains your objection and says it's hearsay, it's irrelevant, or whatever.
Whatever. It violates a rule of evidence.
Okay.
At any point in time, if I, as a defendant, through one of my witnesses or myself, if I make it an issue, then that opens the door. So the judge, when he rules it's not admissible, has closed a door. You can't go through that door anymore. That door's closed. Well, the minute I make it relevant under that relevancy test, does it tend to relate to the case and prove or disprove any part of the case? The minute I make it a relevant part of the case, it's fair game.
Right.
So I've opened that door, and once that door's open, bring it all in. Because let's say I make one page of a book relevant, one page of a letter relevant, you get to bring that whole letter in against me, or that whole piece of hearsay against me, once I've relied on it as part of my defense.
Can't have it both ways.
Right, you can't have it both ways. Once it's in, it's in.
Well, let me ask you this, because this is something that we talk about, again, a lot as lawyers, opening the door. How far does the door have to be open for it to officially be open? And once it's opened, how much behind the door can you get into? What if the door is just slightly cracked open?
This is why I don't ever envy a judge.
Okay.
Right? Never envy the judge. I have said this many times in newspapers and on news, things like that. Is never envy or be harsh on a judge who has to make an on-the-spot decision on something that's important or difficult, because it is an unenviable position a lot of times in trial work. Because everybody's got a side, except for you as a judge, you don't have. I believe that there's a good argument to be made that the stuff that comes through that door still has to be balanced under that balancing test. Is it unduly prejudicial? Is it too prejudicial to the case that the facts of the case don't matter anymore? Are we showing he's such a dirtbag that he must have killed him? Do we get to that point?
Right.
And I think, in this case, they let a whole lot of stuff in. And like I said, we don't envy Judge Newman in making those decisions, because I don't know what I would have done. As a person who was a former prosecutor, as a current defense lawyer, who is very, very interested in criminal law and all its machinations, that limitation is one that's going to be set by a judge. At some point in time, it becomes a piling on, right? It becomes duplicative. It becomes unduly prejudicial.
Right.
And I don't know where that line is, other than I don't envy the guy that's got to make that decision.
Wherever the judge decides
what he decides it's going to be. An appellate court tells him he should have had it.
In this case, we had an interesting situation, and we talked a little bit about this to start with, some of the background stuff, and then some of the things that have happened since the murders. And one of the things that had happened is that 3 months, 4 months after the murders, there was an alleged attempt on Alex Murdaugh's life. He had a flat tire on some rural road out in Hampton County, pulled over, and supposedly somebody passed by, shot him in the head. It was an attempted murder. He called 911. All that happened. He went to the hospital, and as it came out, he later came out pretty quickly and said it was a farce. this is a former client of mine. I gave him the gun. I told him to shoot me. We kind of
I
planned
think
it
he
out.
admitted he had run flat tires on the
Right,
car. No
right.
less. Yeah.
And then, and his whole reasoning, I guess, or what they're saying is because he had a big life insurance policy on himself and he wanted his remaining son to have that. The judge ruled, because that's one of the he did the 403, 404, the balancing test, and the judge ruled that evidence of that was not admissible in this trial. It's obviously not a prior bad act. It happened 4 months after the murders.
And there's some question as to whether it's evidence of culpability.
Correct.
Right. So if you were to rob a bank and then run away from the cops,
Right.
they could bring in the run away from the cops to show your culpability in the bank robbery.
Correct.
So if I'm standing in a group of people and the police come over and they say, hey, which one of y'all robbed the bank? And everybody turns around to talk to them and I run off, they can use that as evidence against me.
And in this case, and this is kind of what I wanted to get your opinion on, one of these opening the door situations that came up, Maggie Murdaugh's sister was testifying, was put up by the state, went through the direct examination. On cross-examination, one of the defense attorneys, I believe it was Mr. Griffin, was asking her questions and was basically asking her questions dealing with her observation of Mr. Murdaugh's demeanor, how he acted, how he'd always acted, his relationship with his wife, his relationship with his in-laws, the concern that they had for him and his remaining son, Buster, after all this. And defense attorney asked several questions and then asked, and I don't remember the exact question, but basically the question was something to the effect of, so you were always concerned about his safety and you were always this and you're always that. And she said, well, I was up until September.
Right.
Okay. And then the defense attorney real quick got off of that, went somewhere else, but boom, on redirect, state's attorney gets back up and says, what happened in September that changed your mind? Objection by the defense. No, that's irrelevant. We need to talk outside the presence of the jury, send the jury out. Your Honor, you've already ruled they're trying to get into this roadside shooting. And then the judge ultimately rules, well, no, you opened the door, because it seems to me in that case, yes, she made that statement. It wasn't really the question that was being asked by the
But did it make it pertinent to the case?
Exactly. And then, but if the door was open, it was ever so slightly cracked. But as a result of that, they were able to have been able to get in all the evidence of that
faking a suicide.
So, I mean,
and heavy lies the head that wears the crown,
right?
That is an unenvious position for a judge to be in. What I think the risk that you do run, because having been and I know the prosecutors on this case are not young straight out of people. This is the state grand jury prosecutors that have been doing it forever. I've had cases with these folks and they've always shot me fair, and I'm not saying this to be derogatory on anyone, so don't think I am. But we sometimes get wrapped up in the zeal of making it work for ourselves.
Sure.
And because we want to win, because we either have convinced ourselves that this other guy's a bad guy and he deserves whatever he's getting, right? Or that we need to win. And occasionally we get so wrapped up in it that we don't think about the appellate issues that could be coming from it. And arguing that opens the door, as much as the defense jumped up and down and raised hell about it, is arguing that opens the door, and then bringing in this vast flood of stuff gives the defense an appellate issue.
Right.
And I'm not saying they're going to win on an appeal should he be convicted.
Right.
But I think that one of the things that prosecutors, me as a prosecutor, I don't even talk about them, me as a young prosecutor, I'd get so wrapped up in the activities of getting my guy, because I'd convinced myself that my guy was my guy, right? That I would find myself occasionally pushing those limits of those rules. I wouldn't cross them knowingly or willingly or anything, but I'd push them all the way to the limit. And with age and courtroom experience, You learn that sometimes you can gild a lily, right? And it's not a good thing because it ruins the flower. And sometimes you've made your point, you make your point and sit down.
Right.
As opposed to opening this appellate issue up in case there's a conviction.
We as lawyers, we all sometimes have an issue and hard time making our point and sitting down.
Absolutely.
Because you make one good point, you want to get to the next good point, and
and because it's our points, we're always convinced they're the right ones, right?
I had this conversation with my wife the other night. I was talking about a law professor that I had in law school, and it said, like, especially on cross-examination, it's a lot like fencing, and I don't mean the fencing like the fence that goes around your yard.
Sword fighting.
You know, you put the little white suit on, and you got this, and you kind of bounce around, and you jump in and stab, and you jump back, and you get in, you make your point, you get out. It's not like you have a machete and you're out there trying to whack weeds in the woods where you're just doing like this.
And some lawyers do.
Yeah, exactly.
Yeah, some lawyers do. And there's different strategies depending on what you want to do on cross-examination.
Right.
And one of the things you want to do, and like you're saying there, like you were implying, is you make your points. You get whatever admissions you think you can get out of this witness without fighting, without screaming and yelling at them and showing you're behind. And then you save those, and you can use them further down in your case. You can use them to not pit the witness, because that's a violation of the rule of evidence, but to impugn the credibility or bolster the credibility of another witness. And then you can use it in your closing argument because you have it as an admission.
Right.
There is a school of thought that you just go in there with a machete and just go hacking everybody up. I find that
just shoot up amongst them and see what's going to fall down.
Yeah, absolutely. But we do have a tendency as lawyers to want to get everything we can get, and it's something that you have to overcome over time.
Right.
Trying cases and winning a bunch and losing a few. I mean, it happens.
To all of us.
Yeah. I wish it hadn't, but I've
had
it happen.
Let
it
me
ain't often, but it's happened.
Let me ask you this, kind of wind down here, and hadn't really, when we had planned to do this back a couple weeks ago. Obviously, this trial it hadn't just started, but we've had a whole lot of stuff happen in this trial since we initially set up this particular conversation, and sitting in our offices 2 weeks ago, and we said, okay, let's do this, because we get together and we do these vlogs. We talk about different issues, relevant things, relevant cases. I think certainly if you would have asked me at that point in time, do I ever think Alex Murdaugh will take the stand, I'd have said no chance in hell. Okay. Not with everything that's been out there and the way this has gone. There is no way as his attorney that I would allow him to take that stand. And today he took the stand. And as we're sitting here, I'm assuming he's still on the stand, and he'll probably be on the stand this time next week. As a criminal defense attorney, explain. Everybody hears Fifth Amendment rights against self-incrimination, rights to remain silent, all that kind of stuff. When someone's accused of a crime and standing trial for a crime, explain that right, that Fifth Amendment right, and then as a defense attorney, what I'd like to hear from you, a criminal defense attorney, is when you're making that decision, and ultimately it's the client's decision.
Absolutely.
With your recommendation one way or the other, when you're trying to make that decision, should I or should I not put my client on the stand? What are the factors that go into that? And what do you think then, and we'll kind of close it up with that, what do you think about the decision for Alex Murdaugh?
I think in that conversation I told you it was an even money bet that he was going to get on the stand. And
that's true. You did say that.
And I think absent all those financial crime, outstanding things to be cross-examined on that could give him 100 years in prison, I thought there was a 90% chance
that he would testify.
He'd take the stand in his own defense. I've seen some fantastic defense attorneys and fantastic prosecutors work on cases, and worked with many on both sides over the years. And some of the most intriguing witnesses that I've ever worked with have either been my clients that have taken the stand, or when I was a prosecutor, defendants that took the stand. you have a Fifth Amendment right not to take the stand, right? You never have to say a single word against yourself to incriminate yourself because, as we said at the beginning, it's the state's got the burden of proof. They have to prove everything.
And they can't use that. The jury cannot weigh that or use that against you.
Can't use it against. There's a whole instruction to the jury
Right.
that you can't use the defendant's silence against him. I think there are certain types of cases, like family homicide cases, murder cases, a lot of types of murder, not all, because I can't paint everything. Every case is different, right?
Correct.
Every case is different. Assault, things involving family, things involving killing somebody, and a few other types of cases where a jury is going to expect in some way, shape, or form to hear somebody's side. And in this particular case, you have everybody in that kennel's dead. And he was there however many minutes before it happened.
Correct.
He's the only person that can tell that story. In self-defense cases, I've had a number of self-defense cases. You and I get in a fight, and you shoot me, or I shoot you, and you argue self-defense, or somebody's breaking into your home and you shoot them. Sometimes, to get across that threshold, you don't want your client to look like a defendant. You don't want him to be Mr. Defendant sitting there. You want the jury to see him as a person. And particularly in this case, there's only one story to tell. There's more than one story to tell because he's told 5 of them. But aside from that, there's one person that can put these pieces together, and he's in the courtroom. And I think that while there's a jury instruction that you can't hold that against somebody, occasionally
it still weighs in the back.
It still weighs in the back of those folks' minds. And some of the very best defense lawyers that I've ever worked with and prosecutors have put up witnesses that everybody on the outside said, that's the dumbest damn thing I've ever heard of, until the jury comes back.
Right.
You know what I mean? And the jury comes back a certain way.
And I agree with you. I mean, from the standpoint of, and the reason why I said there is no way in hell I would put him up is because the judge allowed all the evidence in. So when the state comes up to cross-examine him, we're going to get 3 days of cross-examination about every single financial malfeasance, every client, poor little Miss So-and-so that you stole from, and this person that you stole from, and this person that you stole from. And it's just going to be hammered again and again and again. And
subject to 403, right?
Subject to
that balancing test that a judge will have to give it. At the same time, though, because they could sneak in under prior bad acts, right? These are absolutely issues of moral turpitude. Meaning that
100%,
they're ethical bad things, right? To show that he's of a bad moral character,
right?
But what it can do, and it's a long shot, but it works sometimes, is it can put him in a spot where he says, I did all of that. I stole all of that money. I did all of this horrible stuff to these innocent people, but I didn't kill no damn body.
Right.
And I think that there are certain situations, I don't know about this one because I'm not on the jury, but there are certain situations where that carries a moral weight and it carries a factual weight. And I don't know how good he's going to do. I'll ask my wife. I'm sure she'll tell me all about it when I get home. But I think that there is something to be said for, even though you have a Fifth Amendment right, even though you got a right to remain silent, even though the burden's on the state, if the defense is going to put up a case, which they have here, where they've put up their own witnesses,
own experts,
their own witnesses to interpret the evidence that's already in. Sometimes it's that last voice that needs to be heard.
Right. And I agree with you. Even though it cannot be held against you, you have the absolute right not to testify. The judge hammers that home during his jury instructions. You cannot take this into account. Still, it's human nature. If he had nothing to hide, why don't he get on that stand and tell us?
Why don't he tell us
his side of the
story?
story?
Particularly now at this stage of the case.
Yeah, you might as well, I guess.
Yeah, at this stage of the case, he's on video, being there 20 minutes before or whatever, depending on whose timeline you believe. And in that situation, there's a big empty voice out there. There's a void that nobody's been able to fill.
Right.
All the circumstantial evidence, all the tire tracks that don't match, all the water that's on the ground that may be from rain or may not be from rain, all this circumstantial gobbledygook that's being thrown up there for a jury to interpret. There's one person that can tell you what happened 20 minutes before this happened. right?
Right.
Or if you believe the state, I think it's 3 minutes or 5 minutes, but only one person can tell you. And he was there.
Right.
He was there most recently. He found their bodies, and he was with them before they died. And there's that gap there, and I think that somebody needs to fill it. And then this particular case,
try to,
right. But somebody needs to try to fill it, and I think that this is his attempt to do that. And whether it works or not is completely up to the jury.
Well, we'll know. Maybe I was gonna say we'll know in another day or two. It may be another couple of weeks.
We'll know sometime between now and Christmas, I'm sure.
Well, I appreciate sitting down and talking with me about this. I always enjoy talking about all matters of the law with you, and these are the type of discussions that Scott and I will sit around and have, not only at the office but out on the porch. And it's good stuff. It's stuff that it makes you think. And when you have situations, and again, especially we have a case, this kind of case, and it's right here, and it's right here in our backyard. And you can when you can really kind of pick that apart and start analyzing, it's great. And
I think it's really easy as a lay person, and
Right.
sometimes as a lawyer, lawyers have a tendency to get in the minutia of it, right? But we want to get in the minutia of the law. I believe that a lot of lay people, having talked to your wife and mine about these issues, that and a lot of other people at the grocery store,
and our wives are much smarter than us.
Yes, across the board.
Put that on the record.
Across the board. We just have a little more knowledge in these areas than they do, and people have a tendency to get wrapped up in the facts. We as lawyers who are interested in the law and the rules, we like to get wrapped up in that. And lay people that are not into those sometimes have a tendency to get wrapped up in the facts.
And emotions.
And the emotions. And the things that we're trained to keep out of our cases.
Right.
And the melding of those two things, because jurors are lay people.
That's exactly right.
So
you don't have 12 lawyers on a jury.
You don't. The last place a lawyer ever needs to be is under
on
oath,
the jury.
right?
Absolutely.
But I appreciate you talking with me about it. We have these talks around the office. We have these talks around the house. And I'm glad to have them to talk to everybody else about it.
Well, we'll get back together soon. See what happens in this case and what other new issues come up, and we'll get back together soon and talk about those.
Everybody needs to remember that we're your lawyers at the beach, and we're always here for you. Anything we can ever do for you, give us a call. We got 3 locations around the Grand Strand.